So my name is Sarah Adams-Schoen, and I'm on the faculty here at UO Law. I'm also a faculty member of the Environmental and Natural Resource Law Center here at UO Law. I'm also the former chair of Oregon's LGBT Bar Association. And my scholarship really doesn't focus on, I'm going to just start with thinking about 303 Creative. But as a gay cisgender woman with an adopted child, I stay very concerned, right, about the protection of rights for the LGBT community, and when they, well, what's going on right now? I'll just say that. Yeah. So I do write about discrimination law in the context mostly of environmental justice and climate justice and housing. But enough about me, because you're really here to see these two stars, right? And so let me start with Robin. Right, so Robin teaches con law and at Willamette, right? Yes. At Willamette, and focusing on non-discrimination protections and religious freedoms. And I want to just highlight a couple of things. Robin Maril worked with the Human Rights Campaign, where she served as the Associate Legal Director and as Senior Legislative Counsel, focusing on federal programs, administrative policies, and legislation that impact the LGBTQIA people. I think I'll leave it at that because you can read more. And Jim Oleske, coming from Lewis and Clark. So I love that we have the three law schools of Oregon represented right up here. And Lewis and Clark is also my alma mater. So before joining the faculty at Lewis and Clark, Professor Oleske was the chief of staff of the White House Office of Legislative Affairs for a couple years under the Obama administration. And I did love this point from your bio, and I wanted to make sure nobody missed it. So your research focuses on the intersection of religious liberty and other constitutional values, and you're actually quoted in Sotomayor's dissent in 303 Creative. So not to force you to toot your own horn, but I might make you toot your own horn with that one. So I don't want to take up any more of our time, though, because I just know that 45 minutes is going to fly by when we dig into these topics. And so what I'd like to do is pass to Robin to just give some brief overview, right, of the 303 Creative decision.
Great. Thank you so much, and good afternoon. Thank you so much for having me. I'm really excited to be here and to be talking about 303 Creative. I think it's one of the most interesting and perhaps, as far as impact, wild card cases that we had coming out of last term. This case is, you might think, Masterpiece Cake Shop Part 2, right? It's different. And what we're going to talk about today is it's different for a couple of reasons. The background of this case, again, might seem very much like Masterpiece. It's someone in the wedding industry, or wants to be in the wedding industry. He's a web designer out of Colorado. And what 303 Creative does is create different websites for different businesses or events. And the owner wanted to go in the business of wedding announcements and wedding websites. Then these wedding websites, if you're not familiar, include information about the couple, the event, registry, things like that. But the glitch occurred because Colorado, as you may know, has a public accommodations non-discrimination ordinance that includes sexual orientation. And what the owner of 303 Creative was concerned about is that she only wanted to provide services for this wedding website to different sex marriages. And her belief was that same-sex marriages were, in her words, false. And that in order to produce these websites with language, etc., would in fact be speech, and she just couldn't do it with her in accordance with her conscience. And she actually, this is a pre-enforcement order because she was not actually approached by a same-sex couple that needed a website. The Colorado Civil Rights Commission did not approach her. She instead said that she feared that she would be targeted by the commission. And the Supreme Court said, and the lower courts said that this was in fact a credible fear, primarily because of Masterpiece Cake Shop and the history of the Colorado Civil Rights Commission in enforcing this provision. I think one of the things, again, that's important about this and that distinguishes it from Masterpiece Cake Shop is that it's not a religious freedom case. And I think this is something I really want people to take away, that it's a compelled speech First Amendment issue. Because what she was arguing was that she was having to choose between having a compelled dictated message from the state of Colorado that was in line with their values, or violate her conscience. And that would violate her conscience, or she would face penalty. And the Supreme Court agreed with her. This was a 6-3 decision. Justice Gorsuch wrote the majority decision here. And again, the main crux here is that the court saw it as pure speech and her speech. So that even though she was working alongside couples to get information, this in fact was speech and it was going to be compelled, which would be in direct violation with the First Amendment. And Gorsuch really focuses his opinion around this idea of tolerance and this idea that the First Amendment is designed to promote a complex and diverse United States that is committed to fostering differences of opinion and speech, and that to compel speech and to narrow speech would be in direct violation with the First Amendment. It was really argued that this would benefit everyone, right? In addition to this distinction between speech and religion, I also want to pull out, and this comes out quite a bit in the dissent, which is written by Sotomayor, this idea that there's a distinction between discriminating against someone because of conduct versus status. And what the owner of 303 Creative says is, I absolutely don't want to discriminate against gay and lesbian Coloradans, period, hard stop. I just can't put my voice in on issues of same-sex marriage. It is the conduct that I have a problem with. I am absolutely not discriminating against gays and lesbians. It is just conduct. And the majority really, I think, grabs on to this distinction, and I think that bolsters the free speech argument. The dissent, not so much. The dissent does not see a distinction between discriminating against gays and lesbians and refusing to provide services for a same-sex wedding. The justices across the oral arguments and in the dissenting written opinion have really beautiful language about the purpose of public accommodations laws that are really rooted in this idea of ensuring that your dollar, the LGBT dollar, is worth the same amount as someone else's dollar. And that this is not a question of conduct or same-sex marriage. This is a question of a desire to deny services to someone because of who they are. And I think that's very important because Sotomayor says, obviously the First Amendment does not protect against acts of discrimination, and that this is an act of discrimination. I know that we're going to, in the discussion, talk about specific takeaways. I really also, along those lines, want to talk about what this means for LGBTQ people and what this means for business owners. And I think at core, and this goes to Justice Sotomayor's really compelling dissent, that it undermines the mission and vision of public accommodations as far as the role they play in promoting a just society and a place where everyone feels as if they are part of the community and can participate fully and authentically in the community. And that even though this is a relatively, in a way, narrow decision, it impacts speech in business. I think that begs questions, which I'm sure we'll talk about what is speech, right? What is a public accommodation or a business that involves speech? Is this, could this be restaurants? Could this be other things? It is also more expansive than religion, so it can just be a belief, right? And that's also significant. But Justice Sotomayor argues that this is not the end of the story, and that Americans and American businesses are governed by the Constitution, not just the rules of the decisions of this court, and that every business can make a decision to abide by the values of the Constitution, which are equality and providing dignity to everyone. I do think there is a chilling effect that goes into place here with enforcement of public accommodation laws, and I do think it's extremely empowering to folks that might want to use this as an exception or as a sort of get out of compliance free note. I think it is yet to be seen, and we are seeing movement toward a more expansive understanding of that. But I think that the real work will be done around cabining and educating people.
Yeah, thank you for that. Yeah, so Jim, a brief introduction.
So thank you for having me. As Robin mentioned, the 303 Creative case, although many people think of it as a religious case or a religious rights case, and although there was a religious liberty claim in the courts below, the Supreme Court did not take review on that issue and decided it, as Robin explained, on the free speech grounds. The case I'm going to talk about, Groff versus DeJoy, actually does involve a religious accommodation issue. And as many of you are probably aware, the issue of religious accommodations and religious exemptions have been highly controversial, and the landscape is pretty uncertain. And before I talk about the law in Groff versus DeJoy, I just want to take a step back and sort of talk about two other sources of law that actually have been more involved in probably the cases most of us think about when we think about this raging debate over religious accommodation and religious exemptions. And those other sources of law are the First Amendment's Free Exercise Clause and the 1993 Religious Freedom Restoration Act, that Congress passed, which has about 22 or 23 states have passed their own versions of Religious Freedom Restoration Acts. And in recent years, there have been cases drawing upon the Free Exercise Clause and or drawing upon the Religious Freedom Restoration Act, arguing for exemptions from laws protecting gay and lesbian Americans, for exemptions from the implementation of the Affordable Care Act, better known as Obamacare, and most recently, seeking exemptions from COVID limitations, whether it's limitations on gathering sizes and religious institutions seeking, or religious individuals sometimes seeking exemptions from those gathering limits based on their religious conviction that they need to meet, or exemptions from vaccine mandates. All of these controversies, LGBTQ rights, Obamacare, COVID, have divided America on political grounds, and maybe more relevant to our discussion, have divided judges on perceived ideological grounds. There have been split decisions, including at the Supreme Court level, on all of them. Groff versus DeJoy, on the other hand, involves a religious accommodation law that has flown under the radar comparatively to Free Exercise of Religion and Religious Freedom Restoration Act. And although it might get more involved in some of the hot button cases going forward, Groff versus DeJoy itself involved a much more traditional religious accommodation claim, the claim that a person takes a particular day of the week as their Sabbath and wants to be accommodated and not have to work on that day. And so let me talk about the law that's at issue in Groff versus DeJoy. This is Title VII of the 1964 Civil Rights Act. And Title VII is the employment title of the 1964 Civil Rights Act. It prohibits discrimination on the basis of race, sex, and religion. And of course, we're focused on religion right now. In 1972, Congress amended the Title VII to make it clear that employers have an obligation to reasonably accommodate the religious practice of their employees unless it would impose an undue hardship on the operation of the business. And that probably sounds like a pretty strong religious accommodation right that employees are going to have. But in 1977, in a landmark case called TWA versus Hardison, the court interpreted that undue hardship language in a way that was widely perceived as watering it down. The relevant line that got quoted very often was that an employer can show an undue hardship and not have to accommodate an employee so long as providing the accommodation would impose more than a de minimis cost. There was a strong dissent written by Justice Marshall, joined by Justice Brennan, saying you're ignoring the language of the statute. This is, a travesty for religious minorities. We're not going to get accommodated in the workplace. There were efforts over the years in Congress to amend Title VII to give definition to undue hardship and basically borrow from the Americans with Disabilities Act definition of undue hardship and say it means significant difficulty or expense. These, by the way, were bipartisan efforts through the 1990s at a time when religious exemptions and religious accommodations were actually largely a unifying thing in Congress. The Religious Freedom Restoration Act that I mentioned earlier passed almost unanimously. But that coalition basically shattered at the end of the 90s, beginning of the 2000s. That effort stalled in Congress. Congress never amended Title VII. But then, in recent years, some justices, including Justice Alito, Justice Gorsuch, Justice Thomas, indicated an appetite to revisit TWA versus Hardison. That, of course, led advocates to start filing cert petitions with the court, saying, take this case up to revisit TWA versus Hardison. There were a couple that people thought the court might take. They didn't take, but then they took Groff versus DeJoy, which again involves an employee. It's an employee of the Postal Service who wants to take Sunday as his Sabbath, and the Postal Service was accommodating him for a while, but then concluded they could no longer do so without more than a de minimis cost. It goes to the courts, and the Postal Service wins in the lower courts, wins in the Third Circuit. The Third Circuit says our hands are tied. TWA versus Hardison says so long as there's more than a de minimis cost, the employer doesn't have to accommodate. Supreme Court goes up, grants review, and interestingly, all parties agree that the court should get rid of the more than a de minimis cost standard. So although the Solicitor General of the United States, which is saying that the Postal Service should win this case and should not have to accommodate, is not defending the more than a de minimis cost standard. They're agreeing that that's not the standard. The Solicitor General seized upon some language elsewhere in the Hardison case using the word substantial, that an undue hardship is when there's a substantial cost on the employer. And at the end of the day, that's what the Supreme Court did. The Supreme Court said, yeah, they disavowed the more than a de minimis cost language, but they said we're not overturning Hardison, we're just clarifying the Hardison decision. Under the Hardison decision and under the statutory language of undue hardship, an employer has to show a substantial cost not to have to accommodate. Here's the interesting thing, or two interesting things. One, it's a unanimous decision. So unlike all those cases I started off with that have divided the court ideologically, this was a unanimous decision. But they didn't decide the case. They remanded to the lower courts for an application of this new substantial cost test without, and I'd be curious as to whether Robin disagrees, in my view, providing almost any guidance as to what would and would not be a substantial cost. So this issue is going to no doubt come back to the court at some point, and at that stage, when it comes back to the court and the court actually has to decide what substantial cost means, I don't know if they will be unanimous. Some of you might be familiar with the ministerial exception cases. The court was unanimous in adopting the ministerial exception in the first case that came to it. This is the concept that the Constitution protects religious institutions against anti-discrimination law applying to their ministers. But as religious institutions extended that further and further in terms of the employees they claimed were covered by the ministerial exception, those cases got up to the court and the court started splitting on how far the ministerial exception went. And I think that could happen with this new interpretation of Title VII.
Well, I think that Jim kind of begged the first question, right? So do you agree?
I will also be extremely interested. It did
Let's get
seem.
them
Oh,
up.
I'm so sorry. Sorry, online friends. No, I think I'm very interested to see, given the lack of guidance around what substantial cost means. Perhaps I think it's an opportunity for administrative agencies like the EOC to step in and provide important guidance about this. The EOC was very involved around de minimis, and it's one of the reasons why TWA v. Hardison sort of was pushed up because of that initial guidance in the 60s and 70s. But I think that it'll be definitely an interesting couple of years. Yeah.
Yeah, so it's going to be a while, right? Years before the Supreme Court gives more clarification, right? And you never know, even if it's going to be particularly clarifying. So in the interim, what do you think the effect is?
Of the decision in
Yeah,
Groff?
yeah, of this clarification.
Well, so the first thing that's going to happen, or one of the first things that's going to happen, is Groff itself is going down to the lower court. The Supreme Court, at the end of its opinion, says, we don't foreclose that the United States Postal Service may win this case. It might be able to prove that it would be an undue hardship. It would impose more than a substantial cost for them to have to accommodate Groff. If the Third Circuit goes there, I would not be surprised if the case goes back up to the court for further elaboration. But it could be another case. I should mention, although Groff is sort of this not politically charged, not culture war topic of Sabbath observance, which has long been an issue. The original reasonable accommodation provision in Title VII was championed by a member of Congress who was a Sabbatarian, took Saturday as his Sabbath. And so that issue has been around for a very long time. But there are Title VII cases involving COVID, claiming a right to reasonable accommodation from vaccine mandates in the workplace. That may be less likely now that where we are. It might have been more likely, a year and a half, 2 years ago. There are also issues involving LGBTQ rights and speech by religious employees in the workplace and how that impacts on LGBTQ employees in the workplace. And so that's a context in which this could come up. And again, the decision I would submit doesn't provide a lot of guidance in that area. And I should just hasten to add, I think, the court's going to have to take another case like 303 Creative to wrestle with unanswered free speech issues. I think both of these cases that we're talking about, there are going to be future cases that will potentially go to the court, including one here that's in Oregon, the Sweet Cakes by Melissa case, which is pending right now on remand in front of the Oregon Court of Appeals.
Yeah, Professor Maril, do you want to talk a little bit about what you see as the implications for the Sweet Cakes case?
Yeah, I think that looking more broadly at what the Supreme Court would look for, I think, in a next case, I do think that it goes to this question of really parsing out more completely the distinction between speech and discrimination. And the role that religion does play there, because it really is this sort of messy cyclone in 303 of it is based on religion, it is a business act, it is conduct, but then it is also speech. So I think that the court, although I think that Sweet Cakes by Melissa poses a very similar good set of facts, I think, for folks that want these cases to move forward as far as it is a case around expression and expressive conduct that you are selling. I think that the court has a lot on its plate to parse out, I think, even more broadly.
Yeah. For those who might not be familiar, could you just briefly, what are the key facts?
Yes, I will. I have this information stored back here, so I'll bring it up to the front. So, Jim, please feel free to fill in if I miss it. I think it's extremely similar to the Masterpiece Cake Shop that she runs a business. She does not want to, a cake business specifically in Oregon, and she does not want to provide specifically same-sex wedding cakes that would violate the Oregon public accommodations law, correct?
Correct.
Okay.
The one thing I'm not certain about, and this is actually an issue in a couple of the wedding vendor cases that are still working through the pipeline, I believe she's running her business Sweet Cakes by Melissa in another state currently. And so I don't know, but if she's arguing she would come back to Oregon if, the decision got reversed by the Oregon court. So the Oregon courts ruled against her, and this case has gone to the Supreme Court twice now. It went up to the Supreme Court while Masterpiece was pending. It got vacated and remanded to the Oregon courts, went through the Oregon courts again, they again ruled against her, went back up to the Supreme Court while 303 Creative was pending. 303 gets decided, gets remanded again, vacated and remanded again, and it's now back in the Oregon Court of Appeals. And the last I saw, there was a joint briefing proposal from the parties. I haven't seen if the court has issued an order on it setting a schedule for this fall, but it'll be briefed this fall. Maybe they'll hold oral arguments on it, and maybe it'll go to the Supreme Court for a third time.
Yeah, and I think one thing I think that in non-wedding related news, I think that it will be interesting to see how non-wedding businesses can use this, because I think that's really the kicker of the broader impact. Because I think that the way you describe them as hot button or cultural issues, same-sex marriage continues to be that issue. But what the justices brought up in the 303 dissent specifically are issues around religion and religious identity and racial identity, and not just wedding services, right? Photography services, things like that. And I think that that's really, if the court really wants to provide clarity and guidance, which I don't know that it necessarily does or can at this juncture, that's the question, is, okay, I'm done talking about same-sex marriage and cakes and websites. What does this mean more broadly for the way our Constitution and the American people believe people should be served and protected by public accommodation laws? I think it's a much broader issue, and I think the court would do well to recognize that by taking a case that was more broad.
And do you see it being, 303 Creative, being extended? I mean, when we get into this muddle of speech conduct, we could, I think maybe you have a clear path to, say, photography, like family photos and wedding photos, because at least it's an art. In fact, more easily probably classified as an art than the website, although no offense to website designers. Seriously. But what about beyond that, like beyond the things that are arts at all? It's still conduct.
Well, and I think that definitely begs the question, because it is still conduct and it is still speech. And so to the extent that they have concluded that this is pure speech, and that to be prevented from discriminating would be in fact compelled speech, I think that it does beg the question of how this reaches other businesses. And the justices bring up issues around, historic issues around public accommodations laws and segregation and restaurants and really the traditional cases around this, and remind us of the way both religion and speech were used 60 years ago.
One thing I just want to add about 303 Creative is I think there is a very narrow way to read the opinion, and there is a very broad way to read the opinion, and Justice Gorsuch gives us both. So the narrow piece is that he relies very heavily on the stipulations in the case. Colorado, I'll just say this bluntly, made bad stipulations in this case. Colorado basically stipulated that when Lori Smith is going to be making these websites, she's going to be sending her message of celebration of these weddings. Now, what's unclear is In most cases, are states going to stipulate away that issue, or in most states going to argue when businesses provide services, even if they've got speech, the baker writes happy birthday and maybe writes it very artistically, more artistically than you and I could ever do, but nobody thinks it's the baker sending the message of endorsement. So when that's actually litigated, are businesses, even if they're creative businesses, going to lose, whereas, 303 won because of the stipulations? That's a narrow way to cabin the decision. And by the way, if the court's complexion were to change and the next case didn't get to it until the court's complexion changed, you could see the case getting cabined in that way. The other way is Justice Gorsuch, at one point, echoing, this was the 10th Circuit that said this initially, echoing the 10th Circuit, said that these non-discrimination laws are about expunging ideas from the marketplace of ideas. That Colorado was trying to get, opposition to same-sex marriage out of the marketplace, not just trying to regulate conduct and prevent discrimination by businesses, but was targeting ideas. If that's your interpretation of anti-discrimination law, then anti-discrimination law might violate the free speech clause more broadly. That's an incredibly, and it would have consequences in all the cases that Robin was just talking about. It's completely unclear, I think, at this point, which path the court is going down. I'd be interested, Robin, if you disagree with that, but which path the court is going to go down in the future, and that's why I think it's very uncertain.
Definitely, it reminds me of Equal Protection Clause jurisprudence, that strips out of it protection for Black people as formerly enslaved people. Right, thinking about I know I'm jumping around now within the Constitution, but seeing early on, I'll be careful. I haven't scripted this, obviously, so I have to be careful that I just don't take up too much time. But I'm just saying this kind of stripping out of the intent to protect an oppressed minority, right? The intent for protection, and then treating any impacted group as protected, regardless of minority or majority status and historical discrimination. As you were talking, I was thinking, as you were talking, sorry, Robin, as Robin was talking, I was thinking, it's like a discrimination blind, right? A status blind approach. And then when you do a status blind approach, there's always going to be conflicts, right? When you're talking about, if you protect a religion. Anyway, it just kind of just opens it up a bit to a free for all.
Yeah, well, and I think that I think Kristen Wagner, who represented 303 Creative, did such a spectacular job of articulating why this was discrimination against her client in a way of that it was restricting the free speech, and that it was in fact not discrimination, that she did not necessarily want to discriminate. She really did just want to not be compelled to speak against her conscience. And I think that that conflict and that articulation of a religious person being attacked, it's hard to sometimes, I think, to counter that. But
what was her definition then of discrimination, if it's not discrimination?
Well, because, okay, you ready? Okay, so the idea is that she is not discriminating. So the Colorado statute says you can't refuse service to somebody based on their sexual orientation. And she says, well, holy moly, I don't want to do that. I want to not provide services and engage in speech that says same-sex marriage is okay. I don't care what your sexual orientation is. I just don't want to talk about your same-sex marriage. And Justice Sotomayor, I know that's my face, but Justice Sotomayor does a really good job of saying, but what people have same-sex marriages? Well, people who are same-sex attracted, which gets to sexual orientation, right? Yes. I don't make the law, I just talk about it. I'm
going to use that. One additional way the decision could be cabined, just sort of jumping off on this, is this conduct status distinction. I think Justice Gorsuch believes in his bone what Ms. Wagner was arguing to him, which is discriminating against same-sex marriage is not discrimination on the basis of sexual orientation. Justice Kagan believes in her bones, and you could see this debate play out more in Masterpiece and their concurring opinions, that it is sexual orientation discrimination. But let's assume it's Justice Gorsuch's position is the one that ultimately prevails. Well, it goes beyond, LGBTQ rights. It also means refusing service to interracial marriages, interracial couples, and interfaith couples, but maybe it's cabined by that. And you can't discriminate against the individual because of their race or their religion or their sexual orientation and all the other services, but because marriage is viewed as a conduct and not a status, you would be able to discriminate against the same-sex couple, the interracial couple, the divorced and remarrying couple.
A couple getting married, but in a different religion that you don't agree with.
Right. Yes.
Right. So. Yeah.
But that's a different way it could be cabined. It would be broader than many would like, but it wouldn't apply to all forms of discrimination against protected classes.
It seems like that is how it was, that's at least the cabining justification used.
Right. Although one question, and again, I'd be interested if Robin agrees, I'm not sure the free speech clause necessarily, like if there is a business that says, like, I think this group of people is, damned, and I can't make, speech that supports them, why is their free speech claim any less powerful, their compelled speech claim? I'm not sure if from a free speech perspective, why it's any less powerful. Maybe it's that on the back end, well, they have a free speech claim, but there's a compelling interest that trumps it in preventing discrimination on the basis of status. There isn't a compelling interest in preventing discrimination based on conduct, and maybe that's the way it plays out doctrinally. That's several steps down the road, because one final observation about 303 Creative, there's no doctrine in it, basically. Like the doctrinal framework we're familiar with does not exist in the opinion. So it's a little unclear how that's going to play out.
Let me, I'm just kind of observing the time and realizing I've been really enjoying asking my own questions. But I haven't let those of you out here who I'm sure have questions jump in. We have a roving mic.
Hi, thank you for this conversation. I want to ask a little bit about RFRA, the Religious Freedom Restoration Act. Watching the increasing use of that, I think one of the most egregious was Hobby Lobby, because it wasn't even a person with a belief, it was a corporation. But I'm a little concerned and wonder if you could address the use of RFRA and if the perspective of who's the victim of discrimination. So there's a bill, the Do No Harm Act, that would sort of clarify the original intent that RFRA was never intended to violate civil rights, and would prohibit the use of RFRA if it would cause harm to others. So it's kind of looking at who is the victim of discrimination. So I wonder if you could talk about it in that context. Thanks.
Sure. It's so interesting because initially in the EOC v. Harris Funeral Home case, in the lower courts, they did bring up a RFRA complaint, and it was successful in lower courts. It fell out by the time that it got to the Supreme Court. However, there is the case Braidwell, which the EOC, which is addressing specifically this issue around sort of the scope of how far do discrimination protections actually work in the context of a religious employer. And then the other question is, who is a religious employer? And can, as you talk about in Hobby Lobby, which is not a human, similarly, can a corporation or business that is not necessarily a religious entity claim this RFRA exemption? And I think that it is something that without the Do No Harm Act, I think that it is absolutely sort of bouldering that way toward a broad interpretation of RFRA around Title VII, but I would be interested, Jim, in your thoughts on that.
Yeah, RFRA is a fascinating one because, so RFRA was an attempt to codify Supreme Court doctrine before Employment Division versus Smith, which is a case out of Oregon, that held that the Free Exercise Clause does not provide a right to religious exemptions when everybody thought it did for the period 1963 to 1989, and so RFRA 1993 is an attempt to restore that judicial doctrine. The problem is that the judicial doctrine may never have exactly meant what the judicial doctrine said, and the Congress people who probably passed RFRA didn't know what it meant, but because it was the language that was used in those cases, it then got codified. And once language is codified, it's in a different status than if it's just sort of Supreme Court doctrine. The Supreme Court can tweak its own doctrine and maybe apply it in ways that we think are, but like once it's codified by Congress, the language sounds like it's a very strong right to religious exemptions, and it doesn't have the boundary. So pre-Smith, the court had rejected, even when it was recognizing the right to religious exemptions under the Free Exercise Clause, it was rejecting it in the commercial context. Post-RFRA, the Hobby Lobby case that the Congresswoman mentioned, post-RFRA, the court interpreted RFRA to extend to corporations, and to the commercial context, even though pre-RFRA and pre-Smith, the court had rejected exemption claims there. And I think part of it is just because the plain language of RFRA doesn't capture all the nuances of that pre-Smith jurisprudence, so it would take an additional act by Congress to sort of put limits around it. Interestingly, one of the states that has limited their RFRA and its reach is Texas. I don't know if it's still the case, but for the longest time it didn't apply to civil rights cases. So there are states that have limited their RFRAs in various ways.
All right, well, I think one more
Or we
question?
could do one, quick closing comments, or
Yeah.
one more quick question.
Just see if there's a question. All right, quick closing comments then, I think it is. Am I right? Yes.
Thank you so much. I am around, and I would love to meet and talk with you.
What Robin said.
Oh.